Langston?
Yes.
Lindsay Maynard.
Yes, he has been evaluated already, I believe. Let me get him out.
Thanks.
Well, yeah.
You're not sure he's been evaluated? You want to get him out here?
No, oh, he has been.
Oh.
He's been evaluated.
What are we gonna, what's an announcement?
He is adamant that he does not want any plea deals.
Please, presumed innocent. That done it?
You should.
Yes.
May 30th is what I have.
Yeah, I got his. I got it too. Your Quan's report. Here you go.
Here it comes. You're Lindsay Maynard.
Yes, sir.
In cause number 24 CR 1913, sir. Mr. Adams is here representing you, and you were charged with a third-degree felony of assault on EMS personnel, which, as you know, carries with it up to 10 years in prison if convicted. There is a recent report prepared by Dr. Edgar Kahn upon examining the defendant, and this is dated May 30th, 2025. It's also one dated May 21st, 2025. And these are similar based upon an evaluation on May 13th. And the defendant is declared competent by Dr. Ed Wilcon. I am calling these course exhibit number 1 in this court today's date. Any objections?
No.
This will be a part of the record. Take your days. And May 30th, Dr. Edgar Kahn not only reaffirmed his earlier analysis of competence, but went into the issue of sanity or insanity. Did you think that's going to be the questions? I think he thinks out there is going to be fine. Yeah. Fine. Right. But you got a copy of this May 30th report.
I got this one.
That's 21, yeah. And then Dr. Dupont went on to pick up the issue of sanity or insanity on his 30th day report. We got this. Some competing issues is that the defendant is brought to the hospital with what is reported as a drug overdose in an attempted suicide. And he wakes from sedation in a disoriented state, and attempted to remove the breathing tube, kick the nurse who was trying to assist him, which is, I think, where the assault occurred. Yes, sir. His version is the defendant states he doesn't remember. This diagnosis is delirium, which is now long resolved. Now, delirium in psychoanalysis is a state of mental confusion and reduced awareness characterized by sudden onset of symptoms consistent with confusion, disorientation, and difficulty thinking clearly.
It is a serious but treatable condition characterized by sudden change of mental state, including confusion, disorientation, and reduced awareness. Any delirium is a serious disturbance in mental ability that results in confused thinking and reduced awareness of one's surroundings. And it is obvious in this case, the man was suffering from an obvious delirium. He goes on to state that the determination of sanity or insanity is the province of the trier of fact. And the problem we have here is we got some competing interests. He's suffering under what Dr. Edward Pond calls confusion, delirium, but it's from overdose of drugs, which is not an excuse. You can't overdose on drugs and then start claiming defenses. So
it sounds like he's
fact finder to make a decision on these competing interests. But I think everybody would can see if somebody is is misusing drugs and then is being treated and starts beating up the medical personnel. We got problems. Medical personnel to be protected, and there is the issue of the patient if they are in a reasonable state of mental awareness. But if they are not, because of their volitional misuse of drugs, that's not a defense. That's for, I guess, a fact finder to listen and weigh and make a decision open. But you can't say I'm going to misuse drugs and then later harm personnel who are trying to treat you.
so
If that were allowed, I think most people would say who show up to treat or to take care of someone, and then they find out that this is a misuse of drugs, then why would they want to put themselves in harm's way? Because they can be harmed, and then there's no accountability for it. That's not that it does not seem to be a social standard that we want to go down. Yeah, people need to be treated when they're not well, but the treating authorities should not be left without any type of defense under law. And otherwise, the ambulance aren't going to start showing up at locations if they find out that it's drug overdose. It'll get out pretty quick. But they've got other things to do that are more important than self-harm. So that's what it states. And it's a fact is for the fact finder. You want to go to the judge or the jury, that's your call, but it's a possible defense that can be raised, but it's for the fact finder to decide, and he's competent otherwise. So set it for trial.
But have you been able to talk to him about the offer, or?
I have.
Okay.
I've given him the offer. The last offer we got was a cap of 8 years. I did give that to him, and
All right. You told it to him. It's his decision. It's set for trial, and we'll let a jury roll it out. And
He has a lengthy criminal history and is not probation eligible.
anything else? You understand where we are, sir?
Yes, the
Okay.
attorney said, yes.
Anything else you want to add, sir? No, just
My top attorney was not notified that this was happening today, and I'm trying to get my attorney to call my power of attorney, my caretaker to be here. I have traumatic brain injury and seizures. I've been in the hospital all day yesterday and tonight, and I was missing this court date last time because of having seizures in the hospital. But I need my caretaker here.
We'll subpoena those records.
Okay, anything else? Is set for trial. Thank you. Next is, let's,
Thank you.
yes, sir. Don?
Yes.
Mike?
That's
Leo Cover?
Yes, sir.
That's you, sir? Time's come here. I think we got you, ready, to go. We're going to be picking a jury this afternoon. And as you know, you're charged with the state jail felony of publishing or threatening to publish intimate visual matter in 2231. That's a state jail felony. And also in 23 CR 2232 is another state jail felony of theft of property. And each of these are alleged to have occurred on or about July 30th, 2023 in Jefferson County, Texas. And it looks like the victim is, or the complainant is the same person. And you're still insisting on representing yourself.
Yes, sir.
Okay. We're going to have a standby counsel to help you, John West. But you can take care of what you want to do on your own. You just have to, that's John, who's a competent lawyer. He's going to be there for you. If you ever need to ask him something, you don't have to.
You don't have to.
The law says they're in the bullpen, ready to come out to help you if you need it. This is your life. And you've made, bless you, you've made decisions here on how to represent yourself. And very seldom does this happen, that a defendant represents themselves, but it can under the law. And the important thing is that you're completely and totally appreciating and understanding that you're held accountable, like lawyers are, to know the rules of evidence, the Code of Criminal Procedure, and the Penal Code. Those are the basic codification of laws that come into play in cases in this court, and these are where the crimes come out of. The Penal Code, Code of Criminal Procedure, dictates the way proceedings work through the process from the beginning to end, and then the rules of evidence, or the methodology of how things are presented in court. I was on the Rules of Evidence Committee that wrote these, so I'm intimately familiar and sensitive about the way this is going to follow. What we're going to do is order a jury, and we will select a jury, voir dire the jury, and you're certainly going to have an opportunity after the state goes. I go first and do an overall general set of instructions. Then the state gets to ask questions of the jury, and then you can, if you want. And then that's all for the purposes of selecting a jury, deciding which strikes you're going to use. Then at the end of the voir dire, each party gets to select their juror, select their strikes and make their strikes. And then the first 12 jurors and alternates who have not been struck will be seated right over there. And then we will swear them in and begin the presentation of the evidence with the court's reading of the rules and the instructions to the jury. Then each party gets to make opening statements, and then the state calls witnesses. You get to cross-examine witnesses. At some point in time, the state will say they rest. At that time, you may or may not call witnesses. That's your call. You can take the stand as well.
But at the end of the presentation of the evidence, I will read the jury charge. The parties will make the final arguments, and then jury will go back and deliberate on a verdict. Do you understand where we're going to proceed?
No, I don't, because I haven't been arraigned. This is my first time in court. I haven't asked if I'm guilty, I'm not guilty. I haven't been read the charges. I haven't had a motion hearing on any of my motions. I haven't had you ordered whether I could get subpoenas for my witnesses. I haven't had discovery, which I've asked for from you. I've filed with the court clerk. I've sent the assistant district attorney the letters for it. I filed for 2 writs of habeas corpus that hadn't been heard. I filed motions to quash the indictments that hadn't been heard. I got a motion right here to dismiss the prosecution that hadn't been heard.
You've never
You
seen.
haven't held any of my motions at all.
All right.
And here are the rules that you helped write.
Sir,
That says you should.
When I speak, you can stop
Okay.
because we can't speak over each other.
Sure. Thank you.
She's got to take everything down.
All right.
Follow those rules and don't be rude.
Okay.
Can you do that?
Yes.
All right. First thing, I thought we went over this indictment. You have, no judge has ever gone over this indictment, a JP or anybody else? Do you have a copy of the indictment?
No,
Of the
I don't.
indictments? You've never
I had
had a copy of the
It
indictment?
was on kiosk.
Okay.
It's on the kiosk
All right.
at the jail.
All right. 23 CR 2231 alleges that, in summary, that on or about July 30th, 2023 in Jefferson County, Texas, you committed the state jail felony of publishing or threatening to publish intimate visual matter. This states that with the intent to harm the complainant and without the effective consent of the complainant, you disclosed visual material, namely an electronic image depicting the complainant with her private portions exposed, and at the time of the disclosure, you knew or had reason to believe that it was created under circumstances in which the complainant had a reasonable expectation of privacy and that the visual matter would remain private. And the disclosure of the visual matter caused harm to the complainant, namely the image was posted on a public social media platform, and the disclosure of the visual material revealed the identity of the complainant, and namely that image revealed the face of the complainant and her name against the peace and dignity of the state, signed by the foreman of the grand jury. If convicted of this offense, you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand what you're charged with now in the punishment range?
Yes, I do.
In 23 CR 2232, this indictment handed up also on December 13th, 2023, goes on to allege that also on or about July 30th, 2023, in Jefferson County, Texas, you committed the state jail felony of theft. You unlawfully appropriated property, namely jewelry and clothes and tools of a value of $2,500 or more, but less than $30,000 from the complainant, who is the same complainant as in the previous indictment we read over with you. And she was the owner of that property, and without her effective consent of that owner and with the intent to deprive the owner of the property, you committed this theft against the peace and dignity of the state, signed by the foreman of the grand jury. As well, in this case, a state jail felony carries with it no less than 180 days up to 2 years in the state jail. A fine up to $10,000 can be assessed. Do you understand what you're charged with in that
Yes,
case?
sir, I do.
Okay. Well, I thought Mr. Kimler was working with you before.
No, sir, and I don't know how Kimber ever got a retained lawyer, because I did not retain him.
Wait.
I've never signed anything to retain him,
Okay.
ever, never. My signature's nowhere. I've never retained him, never hired him. I don't know how he got on my case.
Did he ever come to talk to you at all?
One time,
Sir?
one time.
Do you know how that happened?
Yeah, we have jail calls where
defendant's acknowledging Mr. Kimmler, his attorney. He may not be very happy with him at the time, but he's on jail calls acknowledging that. I mean, he's up here telling you this. Well,
Thank you. He gets to speak. You don't interrupt, Mr. Interrupter.
now I believe I think that was some of the confusion with the motions on it because Mr. Kimmler was representing the court. Obviously, is not going to respond to these motions when Mr. Kimmler's representing him while he's doing it pro se. So then,
Yeah, I to this day, I don't understand. We've had this before, and I don't understand how that all happened, how that all occurred. Because read this. This is out of the file. Read that, sir.
It says, "Dear Judge Seasons, please be advised that I have been retained to represent the above referenced defendant on the docket call number 7. Please set the case as soon as filed for docket. The defendant is requesting a speedy trial, and I see his signature. I didn't sign nothing.
Yeah, but it's signed.
He didn't ask me.
Thank you. But doesn't this purport to be something right, Kimmler?
You lied.
Okay. Why do you think he would do that
Sir, I don't know.
for you never paid him any money, right?
No, he says he was retained.
I know, that's what it says.
He's
Lawyers,
retained.
look, I've known lawyers for 40 some odd years. They don't work for nothing.
I never.
Because it's their profession. I mean, they get paid one way or the other in some form or fashion. And some of them also donate their time, and that's what makes it a special profession because they're helping other people, but they get paid for it, or else they're out on the streets poor and destitute. I mean, it's also on this same date. He requests a speedy trial. Just that is the most bizarre thing. But you're not aware of anyone on your behalf maybe hiring him?
No, sir, nobody. I don't have anyone on my behalf but me. And if he's a retained lawyer,
That
according
is-
to the law and the Constitution, I'm still able to file pro se.
and Your Honor,
I'm limited if I have a court appointed lawyer, but not a retained attorney.
Mr. Adams has my computer right now, but I'd probably be able to find those jail calls pretty quick.
Of course, I said he was my attorney. That's what was on the record, but I didn't ask for him. Do you have the record with me signing for him? Sir?
No, sir. You just said
Okay.
just a second ago that you never thought that he was your attorney.
Exactly.
You never had. Now you just
No,
changed
I
your
said
mind.
he was not my attorney.
You knew he was involved in representing
And I've been
something.
filing since last year to try to get him off of it too. The motions are all filed by the court clerk. And in those motions, I specifically say that I never retained him. And that goes back 13 months now.
November 13th.
The same as I haven't had discovery. It's 21 months, my first time in this courtroom for anything like this, other than his motion to remove.
It's like I'm on them all.
Well, it's because someone purported to be your attorney is in charge of the representation of you according to them.
I've been set, reset
And
9 times.
once again, you're going to interrupt all day long.
I thought
Let
you
me
were
speak,
through. I'm sorry.
Mr. Rude. Once again,
I
I used to get
apologize.
chastised in first grade. I
apologize.
learned.
Yep.
Okay, I have this attorney of record, Ryan Kimler, back on 11/20 of 24 in this other case as well. And attorneys, when they purport to represent people, that's they're in charge of their representation, and that they got to be answerable for it. It just doesn't make any sense why this is happening in these cases. And of course, he's not around right now, so I can't really go into. Yeah, this one on 3/12/24, he requests a speedy trial in this other case as well. Which, uh, and it keeps getting resettings sent to him as your attorney. And Mr. Boyd is sending materials to the defendant, to Mr. Kimmler purportedly. Yeah, I guess. Then on 12/2, this was set on a writ hearing, and your attorney was, Kimmler was notified. And then also the state has filed a notice of intent to use at least 4 prior aggravated robbery convictions in your case. Which would, that would enhance the punishment range from a state jail felony in each case to second degree.
Yes, Your Honor. I
felony
believe he's on parole for a 120-year sentence right now or somewhere around that.
You know what? You'll get a chance, Mr. Interrupter, once again. Let him speak. You know what? You do it again, you prevent her from doing your job, and you get held in contempt of court. I've warned you enough. Let's not be rude.
Correct.
Okay, is he subject to an enhancement to second degree felony?
Yes, Your Honor.
I can't.
They are in sequence. There are at least 2 of those that are in sequence.
Okay. Okay. You understand? He's saying he wants to represent himself, which is fine. I'll have a standby counsel of Mr. West at trial, but can you get all this discovery over him as soon as possible?
Yes,
Can
Your
you do it
Honor.
in 48 hours or less?
Yes, sir. We can have him brought over and let him review all everything that we have.
Look, this is terrible because somebody was purporting to represent you, and they're supposed to be taking care of this for you. This doesn't make any sense. This doesn't make any sense. I've never seen this before, pulled. And something is, I presume, a complete, total misunderstanding, because I don't know, Mr. Kimmler is not known to pull fraud at all. He's not a dishonest man. But this is bizarre that this has gone on this long purporting to represent you. I don't understand. And you've never seen him?
One time.
One time. But he purported to say he was representing you then, right?
No, sir.
What did you see?
It was about he come and see me about the blue one being lifted on parole. And the parole was,
Why would he do that for you for no particular reason?
I don't know, somebody asked him, I guess. But it wasn't me. And parole is the whole thing behind this. Just like he keeps mentioning parole. He's more concerned about my parole being broke than any evidence. There is no evidence.
No, he's not. He doesn't have a say in the parole, so he's concerned, like they all are, about doing their job that's relevant in this case. And parole is not the point. Parole, felony, final prior convictions are the point. It's the circumstances of the crime and criminal history. That's relevant.
Yes.
Don't say it's not. It is. Get that to him. This has gotten now. I'm concerned. Cause I want him back in a week to make sure that he's got it all and he's had a chance to look at it and, cause we're gonna get this thing to trial as soon as you've been languishing too long.
So can I have a question, please?
Yes, sir. Go
Are
ahead.
we gonna have a pre-trial hearing on my motions?
Yeah, yeah, we'll do that.
Fantastic.
Yeah, we'll do that and we'll come back in a couple of weeks, okay? We'll set it for then. Yeah, to give them time to get together. All right, that's,
The hearing on March 31st with right for the defendant, you get released right now.
this
For the
year.
record. Uh-huh.
Well, I think it was, yeah, we were here at a hearing before.
Well, right.
Yeah, and that's when,
Motion.
and that's when he was, released, but I think you insisted that,
Yeah.
Absolutely.
yeah. And we went over the importance of understanding and appreciating, self-representation, how, because that's what I would do in these cases. And, just keep, anytime you want to, get someone to help you, but they will stand by and be available. And it's John West, that man right over there. He'll introduce himself to you and you can ask him any questions that you need right now if you wish. Okay, so his is reset for 2 weeks.
Yes, sir.
And it's got my foremost attention out of the 2,500 cases I've got. This one's going to fast track and make sure that you're ready and get this. We'll get this done.
2 weeks for a pre-trial motion.
Pre-trial, yeah, we'll do pre-trial and thereafter we'll set it for trial. Okay, all right. That's all, sir. Thank you. What does that leave us, gentlemen and ladies?
Chelsea Miller, Langston, that's what you're, is that a real reason?
On Chauncey Miller, but did Langston say he's available or not?
Langston just went back there, I think, to talk to him again.
He's showing the video, Your Honor. I think he's trying to get it resolved.
We've got paperwork for,
Okay, can we get Langston out for just a second?
do you want to do that paperwork for Joshua Goth?
Yeah.
Or Goff?
What's going on?
Yeah, David's got something with Goth,
Yes.
Mr. Goth?
Or Goff?
It is there. Very.
I wait for her to get back. Earlier in this case, the defendant entered a plea of guilty to aggravated robbery. A pre-sentence report has been prepared. And have the parties had an opportunity to review it, and are there any corrections or changes, state
No, Your Honor.
and defense?
No, Your Honor.
I can't find Chardarian Parker's plea. It says the plea was entered on 5/12. There's nothing showing up on this screen. Can you pull it out and let me look at it real quick? Thank you. So, if the agreement is a cap of 8 years in prison, what we're looking at is two options. No less than 2. No, stand by. It's a first degree felony, correct? No less than 5, no more than 8 years confinement in prison, or deferred or unadjudicated probation is an option. Regular probation is not available under the indictment, which alleges a deadly weapon, mainly. All right, go ahead, Mr. Grove, you may go first.
Yes, Your Honor, may it please the court.
Yes.
And looking at Mr. Parker's record in this particular case, I hate to say it, but he may be one of the more fortunate people, even though he is charged with and has pled guilty to an aggravated robbery in which there were 3 individuals that went into a convenience store, and Mr. Parker had a handgun. There was no shooting. No one was really, in fact, even pointed the gun at them, but it's a very serious offense. And we look back at Mr. Parker's criminal history. The first thing that I see in looking at his entire criminal history and other background is he is probably one of the few individuals that I have ever seen in front of this court that does not have any drug charges, convictions, or probations, which is very unusual as the court goes. And I think that it's something, though, that will help Mr. Parker as he goes on with his life, in that he doesn't use drugs. What he is, the other thing in this case, look at the age of the three defendants. Mr. Parker has no prior adult convictions. He has actually two probations as a misdemeanor, or juvenile rather, but no drug charges and nothing like that. He also almost made it through high school. He dropped out when he was in the 12th grade, but this sets him up, and he's planning, if the court allows him, to go back and get not just a GED, but a high school diploma from his high school. And that's worth, in my experience, a whole lot more than a GED. But because of the particular circumstances in this case, he can still do that. Now, then, he shouldn't have done this. There's no doubt about that. But Mr. Parker realizes that he came close to just ruining his life forever. Mr. Parker has a lot of family members that are here today. He has his mother, his father, his stepfather, his grandparents are here. He has uncles, aunts, cousins, and a number of family members that are in the audience to show the court that he has family support in this case. This is not a case in which he was going to be left by himself if the court decides to grant him deferred adjudication probation. He also has learned from his incarceration time. He's been in jail for about 4 to 5 months, and has learned that you can't stay in jail and accomplish very much. If the court grants him this deferred adjudication, he plans to return to his mother's residence upon release. He also is one of the few people that if he were granted deferred adjudication, that he has a job waiting for him. This is through his father, through his employment at the refineries. This is an opportunity, Judge, where I think the court saved Mr. Parker just before things got really bad. And I'm not justifying anything that he has done, because none of this is justified. However, considering that this occurred when it did, he was quickly arrested, and probably saved his life in more ways than one. He would ask the court, and we can go into more details that he wants to address the court, to give him the final opportunity to receive deferred adjudication probation, realizing it's a very serious case, but this will basically save his life. He also has one child that he is going to be supporting, living with, as well as the mother, and the amount of family support that this this young man has, I think speaks very highly of his family, but is going to give him a chance to succeed in this case. And so again, without going any further right now, I would ask the court to consider giving him one last chance for deferred adjudication probation.
How many chances has he had?
Judge, we can count.
Yeah.
I believe he has three convictions, and one of them actually was dismissed, I believe, and there were probations. Now he has some other arrests. I'm not saying he does not, but looking at the number of times he has been in trouble, as a juvenile, he has no TDC. He does have what I believe is 2 probations. And then as an adult, he is currently on 1 year community supervision for evading detention out of Harris County. And I believe that is the only thing besides the pending cases.
Well, Judge, there's,
Hold on. Are you through?
Yes, sir.
Okay, go ahead. Say.
there's just one hitch in all this, and that is that in the pre-sentence report, there shows an aggravated assault with a deadly weapon offense on February 5th, which was indicted recently and got assigned to me after this offer was made. And so he's accused of shooting someone. So there is another offense in which he's involved in that we did not discuss in the plea bargain in this case because it got indicted after it came through the pike right as we were dealing with all this.
Yeah.
So he's got another second degree offense where a man was shot in the neck. So
Yeah.
I would dispute that, Judge. I think we were aware of that, and I believe what the evidence shows, and I apologize to Mr. Laird. I don't mean to say anything about this, but I think we did talk about this. There were 4 people in a car that approached another individual.
Mhm.
A person was driving the car.
You're talking about this other case,
Yes, sir.
yes,
but it's been indicted?
Here's
yes, sir. It's been indicted.
Well, but it's
I
not
thought-
being dealt with today, right?
I don't show any other.
There isn't anything else.
There wasn't anything, as I know, the
Is that
plea
what
bargain
you're gonna do?
agreement,
Is
I don't have anything written down that
You
says we
wanna
were
dispose-
dismissed.
I thought we were disposing of that case.
No,
today.
this is the aggravated robbery.
Yes, sir.
Um,
I mean, you can double check the
24C
paperwork. I don't think
056.
there was anything dismissing it if we look at the plea papers. Huh? So there was one done? Okay, then I apologize, Judge. We'll
And
just,
again, that's the way I
Okay, all
recall.
right, all right.
I
Okay,
apologize.
we're just dealing with this matter.
Yeah.
Okay.
I just didn't have it's still an open case in my files. Okay,
He didn't sign
okay.
it.
So,
I'm gonna sign it in a minute.
Okay.
If this disposal. Go ahead.
but otherwise, if he's done with his, I'll give my spiel on what I want on this case.
Go ahead.
Yes, sir.
Go ahead.
Judge, I'm looking at the story of the defendant. Kind of seems a silly excuse for showing a gun to a clerk, that he thought this was a joke. Looking at his prior history, with his chances looks like as a juvenile, he's had several chances of getting probation and getting himself straight. And then he's got the misdemeanors that he had. We would ask for the 8 years. So this is just ridiculous. Sticking a gun to anybody, especially store clerks, we have to protect them from people like this defendant, from placing them in danger, because guns can go off. Guns are intended for one thing and one thing only, and that is to kill. And so we would ask the court to give him the 8 years.
What would you like? Would you like to say anything, sir? If you want, this is your time. It's your life.
Well, yes, sir. I would like to say that I know I made a mistake, and I know that day that I wasn't thinking, but my intentions wasn't to hurt nobody or to scare anybody or to walk out the store with aggravated robbery. I know what I did was wrong, and it ain't nothing to justify what I did, and it ain't nothing to justify for me showing him a firearm and playing around with somebody like that. And I know that it was wrong, but I just want to learn from my mistakes and do right on probation so I can be up for my daughter, be up for my family, and go to work and go home and provide for my son for my family.
Okay.
What have you learned about hanging around with people that are in trouble?
But if I hang around people that get in trouble, I realize they get me in trouble. So that's why within 5 months of me being incarcerated, I realized that I can't hang around nobody unless it's my daughter or my family that's in the courtroom right now.
And you realize that if the judge is very lenient and decides to put you on deferred adjudication probation, but you could still end up doing life in prison.
Yes,
You understand that?
It's
If you screw up one time, depending on the facts, the judge has that discretion to do that.
yeah, so that takes a big part in and why I want to change for the better, because I know the circumstances of this case, and I know if you give me a chance, I know if there's anything that you could have did, and I ask that if you give me probation, I can show probation that I could be better for the community, and you want to see me in your court again.
How many times have you been placed on probation?
One time when I was 16, and one time when I was 12.
You're forgetting a few.
Then at age 17, I was placed on probation for misdemeanor out of Harris County. So, my other case.
Yeah, this juvenile, your juvenile history, you were placed on probation on March 23rd of 23 for 1 year delinquent court probation for unauthorized use of a motor vehicle. And then also on that date, you were placed on probation for evading arrest with a motor vehicle on March 23rd of 2023. Okay, that was a year before this crime was committed. Then while you were on probation, for those juvenile cases, you pick up an evading arrest or detention in Harris County on November 28th of 2023. And then on July 1st, which was 3 months after you committed this crime, you're placed on deferred probation out of Harris County for that evading arrest and detention. Correct?
Yes, sir.
And then you've got this case you're dealing with. So in this pre-sentence report, God bless you. When you talk to the probation office on a pre-sentence report, you have to be forthright and truthful. And I don't understand why people aren't truthful. They have everything to lose because all of this is written down. You state to the probation officer here, you entered the store with two friends, playfully showing the cashier an object resembling a firearm. And you ask the cashier, do you know what this is? The cashier expressed discomfort. Now, these are your words. The defendant, then you put the object away while laughing. And then people stole something, a few items, and took off. That's it. That's what you told the probation office after you looked me right in the eye and told me you committed this aggravated robbery. There it is right here. I am guilty. Well, you signed it. There's your signature right there. Right there. Remember, under oath, swearing to tell the truth. I'm mentally competent. My plea is freely and voluntarily made. I read the indictment, discussed it with my attorney. I am guilty of the offense
and any lesser included offenses. I swear all of this is true, so help me God. And you pleaded guilty to committing, while in the course of committing theft, intentionally and knowingly threatening or placing the victim in fear of bodily injury or death. And you knew you did then and there use and exhibit a deadly weapon, namely a firearm. That's what you pleaded guilty to under oath to me. But you go back after that and talk to the probation office with nothing to lose by telling the truth. And you say you're hedging as to whether you really used a weapon or not. You said it's something that resembled a firearm. But you had pleaded guilty to me under oath for aggravated robbery. Even at the end, you're not telling the truth. Even at the end, you can't be forthright. How can I trust you on probation when you're not forthright with us? You say one thing under oath and then you go back and say something else to the probation officer. It's hard to believe you. You're a grown up. Well, I hadn't been a grown up for long, but you're a grown up. You're an adult, correct? And you've got responsibilities. You've got a family, you've got a child. Yeah. And yet, with the family at home that you're supposed to be taking care of, you're out with some other thugs robbing, using deadly weapons. The victim could have easily pulled out their own firearm and shot all of you. And they'd probably be given an award for doing the right thing and making the town better when they were threatened with their life. But when somebody takes a gun out and places a gun in front of somebody in their face, they think that's the last moment of their life. That's what they all tell me, that I'm no longer in power. I'm no longer in control of my life. Some stranger like you who doesn't have the right to do that is in control. And one stupid, foolish pull of the trigger is the only thing left between dying and living. That's not fair. That's not the way it's supposed to be. You knew better. You had important responsibilities at home. You've been through the system several times. You know, making mistakes has accountability. You're going to be held accountable in this. The fear people have and the waking up with the night sweats and nightmares the rest of their life, looking at a firearm and someone else is in control of their destiny, it's not right. It's not fair. And the law provides punishment for that. And you knew better. You had so many more important things to lose. And yet you made the choice to hang around bad guys and play with guns and threaten people with their life when you should have been at home. And you've been through the system. We've given you chances. You have made mistakes, and you just have made an even worse mistake after being on probation for 2 or 3 cases. I'm giving my spiel. I hate to see a person's life wasted, but each of us makes the choices, and that's what we have to live with, the choices we make. And you have family and probation, people who have helped you know better, and you still did an even worse act than before by threatening somebody's life. And Stephen, and that carries with it, a crime like this carries with it up to life imprisonment. My goodness, that's how we treat it. It's important. It has the same punishment range as murder because it has serious consequences. Oh, here's what I'm going to do. I'm going to find that you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt. in this offense of aggravated robbery with the use of a deadly weapon, namely a firearm. I am following this agreement. You were hereby sentenced. You were hereby found guilty beyond a reasonable doubt and sentenced, as I follow this agreement, to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 6 years. You will be given credit for term for time you have served. And the judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. Do you understand what has happened today, sir? You have been held accountable for making a terrible mistake that you knew better. Now, we have one other case, correct? There is a motion to dismiss that case. And it's 24 CR 1056.
Yes.
Stand by.
Yeah.
It's 25 CR 491. 1056 is what the court just sentenced the defendant to. The other case pending is hereby dismissed as part of this agreement. Do you understand what has happened today, sir? Speak. Okay. Good luck to you.
Is there some further nuisance?